Hello, everyone, and welcome to Asurint's monthly webinar series. We are just waiting a few moments to give everyone a chance to join, and then we're going to get started. All right, we'll go ahead and get started. Welcome to Asurint's latest webinar, Top Trends, Screening Trends in 2025. Today's expert presenter is Asurint's General Counsel, Kelly Uebel. Kelly will be introducing herself in just a minute, but before we begin, if you're new here and you aren't familiar with Assurint, let me just give you a quick intro as to who we are and what we're about. Assurint is innovating the background screening industry. Our powerful, customizable technology, backed by subject matter experts such as Kelly, and personalized assistance help you hire the right candidates every time and faster than ever before. With us, professionals like yourselves leverage faster background checks to reduce manual workloads, minimize compliance risk, promote a safer workplace, and drive insights that boost hiring and recruitment success without sacrificing comprehensive, complete records. A few housekeeping items for today's webinar. We're going to run for probably about 45 to 50 minutes, and then we're going to include some questions at the end. So submit your questions via the Q&A function, and then we will tackle them during that section. And then finally, as a thank you, we're very excited to share with you all our hot off the presses white paper that fleshes out many of these trends. It is called Top Trends in 2025, Background Screening and Hiring Impacts. So that will be sent out with the recording tomorrow. So be on the lookout for that. And thank you, Kelly, for leading this webinar today. And with that, I'm going to hand it off to you.
Great, thank you so much. Welcome, everyone, and thank you for joining us today. As mentioned, my name is Kelly Uebel. I'm General Counsel here at Asurint. I've been with the company overseeing our legal and compliance teams for about 7.5 years now, and have been in the industry for quite some time. I think I'm in year 14 at this point. Previously served on the board of directors, including as chair for the Professional Background Screening Association, and I remain actively involved in government relations efforts, tenant screening subcommittee efforts, and serve on the leadership development committee with PBSA. So just a two-second bio about me there. And before we begin, a quick disclaimer as well that the information here is offered as educational information. It does not constitute legal advice. So everything I say is not legal advice. I always recommend you consult with qualified legal counsel, and you'll probably hear me say that several times throughout the presentation as well. Now we have a pretty concise agenda today. It's all about the trends. And as Catherine mentioned, we do have our new annual trends white paper coming out, which you'll get a copy of this along with the recording of this presentation following the webinar. So I will go through and highlight the content from the white paper, as well as provide some additional nuggets for you to consider when it comes to actions you may want to take after listening to this webinar. So yes, do have some action items, questions to think about, things like that to share throughout. We will have time for questions. I encourage you to submit questions using the Q&A box throughout the presentation, as I do have that up and I try to address them as much as I can as we go along. So feel free to use that feature. So with that, let's go ahead and get started. And I'm going to start with everyone's favorite topic right now, I'm sure, the 2024 election and its impact on the regulatory environment. And as with every election, particularly one that results in the administration changing parties, we can certainly expect a whole lot of change. And indeed, the last 4 days has proved that to be true already. I already had to review the white paper content to make sure none of it had already been outdated in the last 4 days. And I'd like to note that this webinar, we're not intended to be a political dissertation here. So if you're happy, not so happy, or just exhausted about what's been happening, don't worry. For our purposes today, we're going to focus on 3 key regulators when it comes to background screening and the use of such information in employment decisions. So promise, no political commentary here beyond just kind of what's happening at these agencies. So we're going to start with the Consumer Financial Protection Bureau, the CFPB. Now, since its inception, it's been long a focus of attacks by many Republicans. They're not big fans, right? And so during President Trump's first administration, Mike Mulvaney actually acted as the Bureau's acting director, and he took a lot of actions like implementing a hiring freeze. He put new enforcement cases on hold. I think even one year he sent a budget request for $0, saying the Bureau had enough money to do what they needed to do. There's actually a pretty interesting New York Times article from 2019 that broke down how he effectively dismantled much of the agency. And so some of that certainly could be foreshadowing for what we can expect under Trump's second administration. But when President Biden came into office, there was a noticeable shift, especially when the new director was at the helm, and that director is likely to be replaced soon. He hasn't technically been fired yet, but the reports are he's cleaned out his desk, kind of packed everything up, and is expecting to receive his walking papers. And the CFPB over the last few years, again within the Biden administration, they've been very aggressive in pursuing enforcement actions, issuing advisory opinions, entering into sizable consent decrees, like millions and millions of dollars. And last year, we even included the CFPB as its own trend because of all of the activity that they had going for them. And as part of its focus, the CFPB has really honed in on background screening practices and the companies that provide those services. Now, why is this important to you as a user of those services, right? Because the CFPB, they're going to regulate consumer reporting agencies, those that deliver the services. Well, when a regulator acts, it generally causes change in behavior or policies, and that eventually trickles down to you as the user of the reports. And one of the major potential changes we've been tracking here is the CFPB's rulemaking activity as it relates to the Fair Credit Reporting Act. The CFPB wanted to bring data brokers under the definition of a consumer reporting agency, making their actions subject to the FCRA. And this could be impactful to really the data ecosystem, if you will, when it comes to background report preparation, as there are companies out there that aggregate data that don't consider themselves to be CRAs. Now, President Trump, he already issued an executive order freezing hiring and rulemaking activity generally across federal agencies. However, that doesn't really impact the CFPB, but the agency or the Bureau really is likely to follow suit here, especially once new leadership is in place. Although, again, we still don't know who's going to be taking over the CFPB. So certainly still a must-watch item. Next is the FTC. So the Federal Trade Commission is the other main regulator when it comes to the Fair Credit Reporting Act. And the FTC has remained pretty constant and consistent across administrations in enforcing the FCRA and taking action against background screening companies and providers, or companies that they feel were operating as background screening companies, even when they said they weren't. President Trump did nominate Andrew Ferguson. He's a current commissioner on the FTC to take over as chair. He also put up for nomination another commissioner there who, if he's confirmed by the Senate, the FTC will swing back to a Republican majority. And we may start to see an evolution in their enforcement priorities. For example, the non-compete ban, which we're not going to talk about at length today. But I'm sure it's top of mind for many of you as employers out there. Mr. Ferguson is not necessarily its number one fan, and so really probably could expect to see a walking back on that item, and potentially see some shifts in how they're going to approach AI and privacy related issues. And yes, as a spoiler alert, AI is a trend, and we will talk about that towards the end of the presentation. I think that's going to be a big impact in 2025. And then the last agency to cover today here, sorry about that, is the EEOC. So there is a Democratic majority in place until 2026. So immediate noticeable shifts and change, probably not likely right away. However, there has been a lot that's happened already this week. So Andrea Lucas was named as chair. And it's clear based on the first week of executive orders that President Trump has issued that there's going to be notable shifts as it relates to things like gender identity, DEI initiatives, a lot of things that have been pretty important and been a subject of focus by the EEOC. Probably see some changes in how they're enforcing items such as the Pregnant Worker Fairness Act. So there are likely to be some changes over the next several years. Now, historically, I would say the EEOC's enforcement priorities around reducing barriers to employment, looking at things like how criminal history is used at employment decisions, that hasn't fluctuated as aggressively during administration changes. And President Trump in his first administration was generally supportive of certain criminal justice reform efforts. So I'm not sure we're going to see a huge dramatic change there either. And just as a reminder, the EEOC does have an ongoing lawsuit against an employer that was filed back in 2024 over how they were using criminal history in hiring decisions. So that is still ongoing. It should still be tracked. It's EEOC versus Sheets, available on their website. Keep an eye on that litigation. And then I'll just close here with noting that the EEOC, according to a press release they just issued, they had a record year last year. They collected nearly $700 million in various discrimination cases for over 21,000 individuals. And so they are very active. They've been focused on kind of cutting down on their backlog of cases as well. So I think the EEOC is going to be certainly interesting to track and obviously impactful to employers overall. So now we're going to talk about our next trend, criminal justice reform. And I think we can all agree enough about federal politics today, right? So hopefully we don't have to dig too much further into any federal politics, but we are going to talk a lot about what's happening on the city and state levels. And that is particularly evident in criminal justice reform. And so each year we've included some aspect of this concept because it really is a key priority across many cities and states. And generally speaking, it's been one of the few topics that has retained bipartisan support in most capacities. And that kind of bipartisan effort is becoming fewer and farther between, it seems, these days. So criminal justice reform is still kind of one of those key topics. And there's a variety of ways cities and states have sought to advance this topic, whether it's through voting rights, license requirements, kind of easing some restrictions on the ability to get licenses, certificates of good conduct or rehabilitation. Today, we're going to focus on two key concepts that we've talked about in the past, but are important and will continue to be important in 2025, because arguably these are the most impactful to employers from a criminal background check perspective. And the first are clean slate laws. So we absolutely expect to see more clean slate laws introduced in 2025 and likely to be passed as well. And there are already a handful of states listed there that already have this legislation in place. And as I've mentioned, we've covered this concept in past webinars, and we actually just rolled out in Q4 of last year our 50 state guide to clean slate laws. So that's a resource available for you. But as the name implies, these laws are designed to really just wipe the criminal history clean from an individual's records. And so many states already have a petition-based expungement system. These laws are designed to create an automatic expungement of criminal records. And that's in an effort to make the process more accessible, because often seeking out these expungements can be very costly. It can be confusing. It can be time consuming. Often you might need to enlist an attorney. And so it really slows down the ability for people to receive these expungements. And so again, these laws are designed to automatically expunge a record after a certain time period has elapsed. And that then allows people the benefit of having that clean criminal history. And so we've seen these laws passed, again, in a variety of states, including California, Colorado, Michigan, Delaware. Each state, of course, as is typical, seems to take a different approach in terms of the types of crimes that are eligible, as well as how much time must have elapsed before the record is eligible as well. And so we can take a few examples here. Minnesota, my home state, their new law just went into effect January 1st of this year. It allows for the automatic expungement of misdemeanors 2 years after the discharge of the sentence, gross misdemeanors 3 years, and felonies 5 years after. And Minnesota already has a separate law allowing for the automatic expungement of marijuana convictions, which we've seen a lot of states tackle as well. And those are also covered in the Clean Slate White Paper. So there are a number of states that allow for the automatic expungement of certain marijuana related records. And so a lot of estimates in Minnesota are that up to like 500,000 people could have clean criminal records. And so, certainly a pretty big impact there. And then what we've seen really happen, though, when these laws take effect is that states sometimes struggle with how to figure out how to actually automatically wipe these records clean and then to keep like the initial kind of mass expungement. And then how do they keep up with it on the monthly routine basis when new records become eligible for expungement? And we saw this in 2023. Michigan was a disaster, led to numerous delays. There was restrictions on look back periods for the records. There were fees kind of thrown out there randomly. It was a hot mess. New York is now in effect. It has up to 3 years to fully implement the law. But remains to be seen, New York, California, what kind of challenges we may have there. Connecticut, it continues to struggle. It's been trying to wipe records clean, but keeps getting hampered by technological setbacks. And really, the end result for you as an employer is to really expect to experience potentially some delays when these laws take effect. Michigan, again, shining example of that. But also, you should start to expect to see a potential reduction in the number of criminal records that return on reports, especially if you're an employer that doesn't impose kind of your own look back period. A lot of employers these days only want to see 7 or 10 years of criminal history, but there's other employers that want kind of that unlimited period of time. In some of these jurisdictions, California, for example, misdemeanors are eligible for expungement after 1 year, felonies after 4. New York has a little bit of a different time frame, but it is possible for some of these more, I guess, quote unquote, historic records to start to fall off of people's records. And so that may start to be something that you may notice depending on where you're hiring, where you're screening, and kind of what your candidate profile is. The next is the fair chance laws. So we've seen quite a few fair chance laws go into effect within the last year or two. And we expect much more in 2025, either new legislation or potentially cities and states revisiting their existing legislation. And so we've already seen several bills pre-filed or introduced in several states, Kentucky, Texas, South Carolina, all listed there on the screen. South Carolina in particular, there's a number of initiatives that have been introduced in South Carolina that look to tackle kind of criminal history, generally speaking. So if you employ anyone in South Carolina, screen in South Carolina, that's definitely a state to keep an eye on. And Texas is only in session every other year. So when Texas is in session, they try to do a whole lot. So we expect Texas to be pretty active this year. I don't think I need to rehash anything about Los Angeles County here, and then of course San Diego County last year. Those both passed fair chance ordinances. But I think they're a good example of how complex these laws can be, even on the local level, right? The city and county level. And the challenging part of county and city legislation is that it can often be passed without any fanfare. And sometimes they even take effect the same day they're passed, which of course doesn't leave you a lot of time to come into compliance. And so it can be pretty complicated for employers when we start getting into that city and county level activity. Now, as I mentioned, I think we're going to continue to see an expansion of existing fair chance laws as the year moves on. At the end of last year, we saw Madison, Wisconsin revise its longstanding equal opportunities ordinance. So they don't call it fair chance, but it's essentially kind of a similar concept. So they made some revisions to bring it more in alignment with Wisconsin state law. So if you do any screening in Wisconsin, good to be aware of that there is a statewide law that impacts how you look at criminal records. So make sure you're aware of that. Um, the Madison law now, though, requires employers to consider a number of factors, including the character of the employer or the applicant. And it's not really clear, like, how do you evaluate someone's character necessarily? So if you're impacted, if you hire in Madison, probably worth talking to legal counsel about what that looks like. Finally, we're keeping an eye on the New York City Commission on Human Rights. They're always active, they're always doing something, right? And they've been considering amending the rules that govern the New York City Fair Chance Act, which is probably one of the hardest laws to comply with in the country. These potential changes include expanding the waiting period between sending the pre adverse and final adverse action letter, adding new protections for individuals based on certain types of criminal history, like pending cases, as well as adding more protections and new protections for current employees. So I would anticipate the comment period closed in the latter half of 2024. So I would expect to see something likely in 2025, but we'll keep an eye on that for sure. Okay, moving on to litigation and enforcement. And again, this is one of those trends that keeps coming back year after year because people keep getting sued. And it's an unfortunate kind of reality in this day and age, but it is happening. Even if the federal regulatory environment starts to cool down, there is going to be plenty of activity on the litigation front and state enforcement as well, especially in places like California, but places elsewhere as well. And so, from a litigation standpoint, if we stay focused on the Fair Credit Reporting Act, it's the same kind of year over year in terms of it's increased consistently, but also in terms of the focus points. Adverse actions seem to be a pretty popular target in 2024, and I think we can expect to see more of the same in 2025. And plaintiffs' attorneys are really drilling down into what they see as being like technical details. So it's not really a question of did you send adverse action, because hopefully everyone listening in and employers that use background reports have an adverse action process well thought out and in place, but really the kind of the mechanics of the process. And so kind of put a few action items and things to think about on the screen here, but looking at things like, was a score applied to the order that implied a final decision? So are you marking your reports with a fail, ineligible, do not hire before a pre-adverse action letter is sent? Did anyone come into contact with the candidate to reject them before the pre-adverse action letter? We've seen a number of cases over the years where the person said, look, I got texted by the hiring manager, hey, John, thank you so much for all your time, but I was just told by HR I can't hire you because of the background report. Meanwhile, John hasn't even gotten his pre-adverse action letter from HR. And so, boom, lawsuit. They're saying that you took adverse action by sending that text. And so all of these things are really important for employers to stay on top of. And so along with the disclosure forms, really recommend at a minimum review your forms and letters on at least an annual basis. And I'd really recommend getting the help of qualified legal counsel that actually specializes in the FCRA. So there's a number of firms across the country, larger, smaller, and everywhere in between, that actually specialize in the FCRA. And so I think that's a really worthwhile investment for you, especially because, looking at some litigation reports, as of October of last year, FCRA lawsuits filed were up over 10% from that same time period the year before. And this is like consistent year over year going up. And so really important to make sure you're training your staff on compliance protocols and kind of what to say, what not to say with candidates. and look at the terminology you use. So all of that is really important. So beyond just having your letters and forms reviewed by qualified counsel, you may want to bring them in and just kind of have a checkup, right? Like, when was the last time you really looked at your process end to end, from when the offer letter goes out to when the background check is being considered to what you do after? If you haven't had that kind of end to end checkup done in a while, it's going to be worth the investment in terms of potentially cutting down on some of that legal liability. So beyond the FCRA, we've seen a rise in lawsuits and regulatory activity on criminal history use. And there's a number of private lawsuits that have been filed across the country when it comes to employer use of criminal history information. I don't have any of that tracked and covered here today. We've covered it in past webinars, but definitely it is an issue. Want to focus today on some regulator activity as well. And so, of course, California, the Civil Rights Department has been remarkably active when it comes to the Fair Chance Act. And in December, actually announced settlements with several major employers: Amazon, IKEA, Kohl's. I think they even got the Dodgers in there for various violations of the state's Fair Chance Act. And then back in 2023, December of 2023, they filed a lawsuit against a grocery chain that remains ongoing. And they billed it as the first of its kind in enforcing the Fair Chance Act at that time. And so a lot of the issues that are plaguing employers are denying jobs to otherwise qualified candidates, where the criminal history has no adverse relationship to the position. Employers are not performing individualized assessments. Again, these are all the various allegations. Not performing individualized assessments of the criminal history. Inadequate notification about why someone is having their conditional offer withdrawn, and still having unlawfully including criminal history questions on a job application. And so those are some of the various ways that employers are kind of getting hit by the CRD. So if you're thinking to yourself, well, Kelly, I don't hire in California. No need for me to be listening to you. I know you love to talk about California and I don't care. Well, you still need to pay attention because there are other cities and states involved. Philadelphia, for example, and this actually wasn't a regulator action, it was a class action lawsuit, but wanted to just include it anyway. Philadelphia, this employer had to pay over $1.8 million to resolve a class action over alleged violations of the city's fair chance law. And it was all over having the criminal history question on an employment application. $1.8 million. And we're seeing activity in New York City, DC, as I mentioned, private litigation in several parts of the country on criminal history use. And so really, this is an issue. You need to focus on it. And this is, again, a great place to bring in some qualified legal counsel to look at your process, your adjudication criteria, why you're rejecting people, how you're rejecting people, and see, if any changes are necessary. And also, if you still have the criminal history question on your employment applications, highly recommend discussing that practice with counsel as well, to see, are you in compliance with any applicable local or state fair chance laws? Because some of them say you can't have the question on there at all, as well as, what's the true value of keeping that question on your application? How are you leveraging it? Is it really important to you at this point in time? And so that may be another place you want to spend a little bit of time talking that over. All right. So, of course, again, no trends white paper is probably complete without marijuana, right? It's still an impactful issue, challenging employers, even if the legislative side of things has actually kind of slowed down somewhat. We didn't see that explosion of activity throughout 2024. But one of the bigger items to watch, of course, remains the efforts to reschedule marijuana. And so there was supposed to be a hearing in December. It was pushed into 2025. A lot of experts, from what I've read, don't believe rescheduling is actually going to happen in 2025. But in the white paper, you'll actually see a link to an article from the Marijuana Moment site. And it's actually a pretty good informative resource overall, this website. Of course, I'm not endorsing any organization or cause, but they generally have like maps and guides and interesting commentary on the issue. So you'll have a link to the article. But in this article, they note that there's kind of some controversy brewing here because the DEA has apparently been collaborating or allegedly been collaborating with organizations that are opposed to the rescheduling effort in order to prevent it from moving forward. So again, worth a read once you get the white paper. And of course, with the change in administration, it's kind of unclear what the future may hold for marijuana on the federal level. So it hasn't been, anything that's been definitively decided, what's going to happen on this topic, at least not that I've seen. Now, on the state level, there were several ballot initiatives in the 2024 election because let's remember the election didn't just impact the federal level. There was also some statewide implications, and most of them failed. So North Dakota, South Dakota, Florida, they all rejected some sort of initiative that was either aimed at medical or recreational marijuana legalization. Nebraska did vote to legalize medical marijuana, but legal challenges were kind of swiftly filed right after. And although not touched on here, and obviously not marijuana, I did just want to note that voters in Massachusetts voted against legalizing the possession and use of natural psychedelic substances. So, still a battle there in Massachusetts, and we've kind of seen the psychedelics be talked about in some other states as well. So, who knows? Maybe in future years that will make it to a trend. Not quite yet. But yeah, Massachusetts said no thanks to legalization of psychedelics at this point. But as we discussed with criminal justice reform, what makes this even more challenging of a concept is the local level activity. So, as I noted, cities often pass laws without anyone really knowing about them. And that was true in Pittsburgh. So, last year, Pittsburgh, in the latter half of the year, passed an ordinance making medical marijuana patients a protected class under the city's anti discrimination law. And that impacted most marijuana related drug testing. Of course, there's exceptions. So it's important for employers to really try and stay on top of this local activity as well, in addition to the state and federal action. And I do see a question about kind of are more and more companies removing marijuana from their pre-employment drug testing panels. And I'll say, just from our experience, we've kind of seen a mixed reaction from employers. We certainly have seen an increase in requests to remove marijuana from the panel, keeping drug testing in place, but just removing THC from the panel. There are some companies that are steadfast in wanting to continue to test for it. Of course, if you're regulated, right, let's say you're regulated by the DOT, you have to keep that for your kind of safety sensitive positions. We've seen some employers who've chosen to take more of a state by state approach, which is interesting, right? Because like California and Washington, there's only certain ways you can test for marijuana now, and you can't use results in certain ways. And so unfortunately, there's not like a one size fits all. I think what's important to start to think about if you're considering removing marijuana from the panel is, what's your industry, right? Like where do you operate? What positions do you hire for? Are some positions required to have certain testing done? You may want to treat someone that's operating a forklift differently than an administrative office employee, for example. And what do your workplace policies say? Because I think it's worth reviewing your drug and alcohol workplace policies as well, and figure out how you're going to tackle that, especially if you're hiring across a number of different states. All right, next on the marijuana topic is litigation. So we've seen litigation continue to grow. I think every single week I see multiple news alerts about employers being sued for either revoking conditional offers or terminating employees over positive marijuana drug tests. And maybe this is a factor in your overall consideration too on whether or not you want to keep testing for marijuana. And this ruling from Florida in particular is well worth a read. Reach out to your legal counsel and talk to them about this one. It was really interesting. It involved an EMT He was, put on leave for testing positive for marijuana. He said, "Look, I have a valid prescription for medical marijuana in the state of Florida." And the court actually ruled that the employer needed to accommodate off-site medical marijuana use, which is kind of mind-blowing, right? And when we talk about that, because even a lot of lawsuits we've seen under the ADA, the Americans Disabilities Act, has not ruled accommodation to be required since marijuana is still illegal under federal law. And we've seen some other states go a different direction where even though marijuana may be legal under state law, the way the laws are written in that particular state, it's still legal under federal law, so you don't need to accommodate it. And so this Florida opinion could be pretty interesting. And the court looked at the state's medical marijuana law and also found the employee to be disabled under the Florida Civil Rights Act. And so, based on these variety of factors, they determined that he is entitled to accommodations, and that could very well include accommodating medical marijuana offsite. Pretty interesting ruling. There's more detail about it in the white paper as well. Highly recommend a read of that one. Now, unlike Florida, New Jersey kind of offers a slight glimmer of hope for employers in this recent ruling. And this case has been going on for quite some time. But New Jersey has seen a lot of litigation over marijuana related testing. So this is a good case to look at with your counsel. But it basically found that there was no private right of action created under the state's marijuana law. So essentially no ability for an individual to go out and sue an employer, for example, directly. And so definitely worth kind of reading and looking into, especially if you're in New Jersey, where I mentioned litigation has been pretty prevalent. And so definitely worth a review. All right, our last trend of the day: algorithmic discrimination and automated decision making under scrutiny. That was the most concise title I could come up with for this topic. And if you're like me and you see these words and concepts and your brain starts to just shut down a little bit because you don't want to pay attention to it, it's time to start paying attention to it. We're seeing heightened attention and focus paid on especially algorithmic discrimination, as well as the use of automated decision-making tools on the state level, which we're going to talk about in a minute. But it's also been a very hot topic on the federal level. And I know I kind of tried to say no more politics. I'm sorry, we have to talk about it because there could be a shift here. And so this was a big initiative under President Biden's administration, kind of a focus on AI in general. And so several agencies, CFPB, EEOC, FTC, Department of Labor, Department of Justice, there was even more than that. They all signed on to a joint statement highlighting how kind of automated systems may actually end up violating federal law by leading to unlawful discrimination. And we don't know exactly for sure what's going to transpire as President Trump takes over, but he already issued an executive order reversing President Biden's executive order on AI. So if you're like me, kind of getting some whiplash from all these changes here. And so we'll see kind of what happens, especially depending on like who takes over the CFPB and what Andrew Ferguson's priorities under the FTC will be, things like that. One thing I did want to highlight is there was actually a bipartisan House task force on artificial intelligence created, and they finally, in December of last year, just issued a report. And it's a pretty interesting read. I put a link to it there. It's lengthy, but it's nicely broken up by topic, and it covers a variety of topics, including potential privacy related impacts, as well as their recommendations for what the government should do. And they also noted that the improper use of AI can violate laws and deprive people of their civil rights and liberties, potentially causing harms like bias and discrimination against protected classes. And so that's kind of the theme that has been going through all of these agencies. If you look at some of the EEOC activity on it, and the EEOC activity is featured more prominently in the white paper than what we're talking about here. But they're really focused on how the use of these tools can end up causing discrimination. And so that's really one of the key points here, and that's going to come up later in some of the state activity too. Actually, before I dive into the state efforts, I did just want to highlight something else from the CFPB. Again, it's talked more about in the white paper, but they did publish a circular, I think back in October, where they warned employers of what they called, quote, unchecked worker surveillance, noting that like a lot of the tools that employers are potentially using may actually constitute consumer reports that are then governed by the FCRA, which is pretty crazy, right? And so some of the tools they reference were tracking driving habits, measuring the time taken to complete tasks, keystroke frequency. So really good idea to think about any tools you may be leveraging like that and talk to your legal counsel about what they think. Because if it is subject to the FCRA, arguably that could trigger things like the consent, so disclosure forms, and adverse action. And so that's not really something I think a lot of employers have necessarily thought through. And the CFPB, again, just issued a warning on it. And it's worth a read. There's a link to the warning in the white paper. So that's probably a good place to spend some time talking to your counsel too. Now, on the state level, California and Texas, not two states we generally talk about in the same breath, tackling the same issue. But Texas actually just introduced a pretty extensive law on this topic. And definitely, if you hire in Texas, that's one you're going to want to track. California is considering regulations. So Texas is a law, California is more regulations. But again, they're both designed to govern the use of automated decision making and kind of AI more broadly. And some of the concepts we're seeing in these laws is requiring disclosures to consumers prior to the use of such technology. And so California calls it a pre-use disclosure, for example. Texas has the concept of human oversight of whatever AI systems are being used. There's potential privacy policy impacts, potential requirements to comply with requests from people to access more information about these systems and to opt out of their use. In other laws like New York City's law that's already in effect, we've seen a requirement about bias audits. Colorado is kind of taking a similar path. So a lot of interesting concepts being discussed here. And I'll note that New Jersey, the Attorney General there just recently issued a press release of sorts saying that the New Jersey law against discrimination applies to algorithmic discrimination the same way it does to any other discriminatory conduct. And there's some pretty helpful resources out there that New Jersey has published generally about the law against discrimination. But really what you can see here is that it's becoming a very big focus point for several states at this point. Now, as we know, there's a lot of unknowns and kind of a lot of confusing concepts when you start to dig into this world, right? So I was just thinking about this and some of the questions that I would ask if I was looking at, the tools used and the systems in place. So I put some of those on the screen here, but I want to make a point first, and is that across some of the statements that have been made by federal regulators, as well as in some of these state activity and potential state legislation, there's a common theme that employers cannot escape liability just by claiming that it's not their tool, that they don't develop it, they don't own it, they don't control it. You may still very well be liable for a third-party tool or system that you use if there is some sort of impact based on, whatever that the automated decision making or algorithm that's in place, if that causes any sort of bias or discrimination. And so this is why it's really important for you to understand how are you leveraging this automation, these tools in your hiring and employment processes, because a lot of these are looking at the pre-hire phase as well as kind of post-hire when they become an employee. And I know a lot of employers are trying to look at, how do I take humans out of it, right? I need to make this faster. I need to make this easier. I need to cut down on my budget and my resources. And so I need to leverage automation to make things go more quickly. And that's certainly something that employers everywhere are trying to figure out how to do, right? But where do you keep human oversight in place? How do you keep humans involved? And in places like Texas, if that law were to go into place, that would be kind of a requirement, right? Do you understand? Have you talked to the third party that's providing this tool or algorithm, whatever you want to call it? Have they done any sort of bias audits or any sort of studies to see if there are disproportionate impacts on protected classes? And there's actually been a lawsuit going against an applicant tracking system, if you will, where a gentleman filed suit after he noticed he was submitting hundreds of resumes. And after he changed his name, he all of a sudden started getting calls back. And so he's alleging that essentially whatever sort of resume scanner or technology that was kind of operating behind the scenes was kicking his resume out based on his name. And so he's saying, look, there's some racial discrimination here. And so it's a pretty interesting case. And that tiny snippet I just shared with you probably doesn't do it justice, but definitely illustrates that there's a very real problem potentially here and a risk. And so this is where you should start to think about some of these questions, and do you have the right expertise and personnel to tackle this internally? It can be a pretty complex topic, and so if you are going to be impacted by one of these laws or regulations, if and when they take effect, how will you handle notifying applicants? How will you handle requests for people to opt out of the use? Some of the laws, like I mentioned, New York City requires bias audits. How are you going to do that? So there's a lot to consider and think through. So just kind of wanted to get the brains percolating on this topic for now. And so really another good place to spend some time in all of your free time that you have thinking through this topic. So with that, I think we have about 10 minutes left for questions here. I know there are several questions in the chat box and the Q&A feature. Please feel free to keep them coming. I'm going to go ahead and just kind of scroll through and pull some out. But as you mentioned, as I mentioned, please feel free to keep putting them in there. So with expungements, do applicants still have to disclose the arrest? So that's pretty interesting. The concept of an expungement for the average employer, the average applicant, is that an expungement means it no longer exists. In a lot of instances, especially when records are sealed and not expunged, they're still available for like law enforcement use, but they're not to be used for employment, and they're not to be kind of delivered by a background screening provider, for example. So an expungement, the point of these clean slate laws in particular is that they no longer have a criminal record for the purposes of your need to know. And this is where, if you still ask about criminal history, it can get a little tricky, because no matter how well you word the question, and if you have disclaimers for certain jurisdictions saying, if you live here, don't answer this, or only tell us 7 years, people don't read the instructions all the time or understand them, or they feel that they need to over disclose in case they get dinged about falsification on their application. And so you may end up getting information you don't want to use and you don't need. So a few different considerations there. Another question about when is South Carolina supposed to be considering this? I think that's in reference to the various ban the box laws. A lot of states are kind of just now coming into session. And so some of these states are still in what we call like a pre-filing mode, where they just dump a bunch of legislative efforts, a bunch of bills, and then they all have to go to a committee, they have to be considered. So many bills just kind of die right away. or never really make it past the first step. So it kind of still remains to be seen how the South Carolina efforts may move forward. But with the number of different bills kind of circulating around the same topic as it relates to criminal history use, both for public employers and private, that's been introduced in South Carolina. My guess is it'll at least get some attention and discussion. And so Assurant, one of the things we do is we make sure we track legislation on the local and state level, and of course the federal level, but I mean, let's be real, it's really the local and state level that impacts you the most legislatively. And we do issue updates when things happen via our blog, client communications, our monthly newsletter we send to clients. And so definitely make sure you're keeping an eye on those various resources. Uh, okay. There was some questions about some of the cases with like Amazon, IKEA, Kohl's that I mentioned. The California Civil Rights Department, there is a link, I believe, in the white paper to those. But if you go to the California Civil Rights Department, they have a whole press section on how they sue employers, basically. And they always issue a press release whenever they have a settlement, so you'll be able to find it there. But definitely, I'll make sure I follow up with you with folks asking that question as well, and just make sure you have it in an email. We've talked a lot about marijuana, a lot of great interactive chats on marijuana today as well. It's always nice when everyone shares their perspectives. Okay, question about social media screening. Okay, so uh, we didn't talk about social media screening today, but I know it's kind of a hot discussion, and more employers are kind of dipping their toe in that water. And I think there are some pros and potentially not pros to doing social media screening. But as suggested, if you are going to do social media screening, you are going to want to enlist a professional, right? So there are companies that specialize in social media screening that background screening providers will use to offer the product as well. And with that, you tend to have a better filtering, some accuracy, of course, considerations, because how do you know the profile you're looking at is actually your person or not, right? There's always some concerns around protected class information that can arise with social media. And so I think before you just go full force into social media, it's worth, reviewing some of the potential pitfalls, understanding the product you're getting, understanding how you're going to use and leverage the product. But it certainly is out there. People use it all the time, and it is pretty widely offered at this point. So certainly something Assurant can discuss with you further. So definitely feel free to reach out if you'd like to have a more in-depth conversation about social media screening. Okay, I think we're getting rather close to the end here. All right, has New York City taken any legal action against employers or software companies alleged to have violated its AI discrimination law? Not that I have seen yet. Admittedly, I didn't do a thorough search prior to this, but it's a relatively newer law. So generally, it takes a little bit for the regulatory bodies to kind of catch up. Like the Fair Chance Act in California was around for a really long time, and it's only recently that it's been more publicly enforced, I guess. I'm sure employers have been dealing with issues on that for a number of years. And so by no means do I think New York City will not enforce it. They really enjoy enforcing their laws, making sure employers are aware of the various laws that are in place, because New York City prohibits a whole lot of things, right? Credit use is regulated, criminal history, now AI, things like that. And so, yes, it is likely to be enforced soon. And I can follow up with you on the name of the AI discrimination case I mentioned as well. It's a very, very interesting case to follow. And yes, the report on AI is 273 pages, but it does include very helpful hyperlinks. The House report I mentioned, so don't worry, you can get through it. I have faith in you. All right, so I think that's about all we're gonna have time to tackle today. Thank you all so much for attending. Really appreciate it. As mentioned, you'll get the white paper. Feel free to follow up with us with any questions you have as well. I'll be following up with folks that put questions in the chat. If I feel like they didn't get adequately answered or you're asking for links, I will follow up with you via email. And I hope you all have a wonderful rest of your day. Thank you.